Hi, my name is Mark Daly, and I'm an immigration attorney. And we are going to be going into the issues around children and how to petition for a child when you are marrying a U.S. citizen and you are here in the country on a visa, and that child may or may not be with you. And so the first thing I want to say, though, is that I have a standard disclaimer that what I'm going to do is I'm going to go through the rules relating to children and the different ways that the Immigration Service wants to see petitions coming in for children. And because I don't know anything about your children, I can't really advise you on what to do in your specific case in order to get your children a green card. Now, when my clients are here in my office, I'm able to tell them what to do, exactly what to do, because they're telling me the specific information of their case. However, since I don't have that information from you, you have to realize that what we're doing here is not giving you legal advice, so you can't rely on it for legal advice. However, we are going to be going through the USCIS website and the Immigration and Nationality Act, the actual law, as it relates to children's issues. And I have found that the website is confusing and the laws are complicated. So most of my clients complain about that. We've got a lot of complaints about the Immigration Service website being confusing. So we're going to go through it tonight, and I am going to show you and describe to you different situations that pop up that might help you gain more understanding about which children can come in, which children cannot come in, and what kind of documents you're going to need in order to qualify a child to get a green card. So I'm going to switch over to the screen capture now, and we're going to walk through some of these issues step by step. Well, here we are at the USCIS website. This is their homepage located at uscis.gov. And there is, in this website, a lot of information about permanent residence. If you see on the left, more information, permanent residence, green card. So that's what we're looking through. Now, this website right now, this page has a lot of information about getting getting children into the United States. So look at this one. How do I become a permanent resident while in the United States? Okay. There's all this stuff. However, I've gone through this and I could not find the specific one on the children. So you'll see over here, here is a search box, and what I'm going to have you do is type in child petition, CHILD-PETITION, child petition. You see it over there? Hit enter. Okay. Now the top result here is there's 801 results. The top one, petitioning procedure, bringing a child, son or daughter to live in the United States. Okay, this is very helpful. This outlines what's going on with the procedures. And so I wanted to show this to you. And before we go to there's also a part where we have the laws and the regulations. So let's go into laws and regulations, and Immigration and Nationality Act over here on the left. Click on that. Immigration and Nationality Act pops up. There's the hyperlink down there, and it'll come up to this page. And in Act 101 there are definitions here. So click on Act 101, and here is your forward arrow up here, next document. So let's click on that. We're going to go to 101B. This is Act 101A. Okay, click the next document arrow there. 101B, here we go. Now it's at 101B that they define what a child is. And in the context of petitioning for a U.S. citizen, for a child of a U.S. citizen, then it's in this definition we're going to learn what is a child. So let's look at this. The term child means an unmarried person under 21 years of age. Okay, there's two issues right there. Unmarried and 21 years of age. Okay, now the first thing, let's talk about unmarried. An unmarried person under 21 years of age. It means that at the time the petition is filed, that person's unmarried. So they may have been married before and then divorced. So at the time that they file the petition is at this moment, if they are unmarried, they are a child. So they could have been previously married, but as long as they're unmarried when the petition's being filed, it will be considered okay, because they will be considered to be a child. Under 21 years of age. Okay. So the child is under 21. Now over 21 is what they consider to be a son or daughter. So these are the words that they use. So child is an unmarried person under 21 years of age who is, now under 21 years of age, there's quite a bit of information on this issue too. And when I first started practicing, we had a lot of emergency cases because husband and wife get together, they get married. Husband wants to file a petition, an I-130 for the spouse. Husband also wants to file an I-130 for the child. However, the child is going to be turning 21 in 2 weeks. What could we do? Well, we had to do these extraordinary measures to get the petition filed on an expedited basis, and we'd write age out on there, and we would go and file it in person because it was an age out. It was a very elaborate process to capture these children before they aged out, because once they were a son or daughter, okay, they weren't an immediate relative anymore. There was no visa available, and they had to go to the end of a line that was many years long for an adult child of a U.S. citizen, which is like a third preference category. Since then, in 2002, they have passed a law that is called the Child Status Protection Act. And this is a great law because what it says is basically when you file the petition for the child, if they're under 21 at the time that that petition is filed, they will not age out. And I want to go into that more in depth to get you understanding the nuances around that. So for right now, 21 years of age is still going to cover some children who are actually over 21 years of age because of the Child Status Protection Act. But the term child means an unmarried person under 21 years of age who is a child born in wedlock. Okay, so what that means then is a married couple having a child. Second, B, a stepchild, whether or not born out of wedlock, provided the child had not reached the age of 18 years at the time the marriage creating the status of stepchild occurred. So that is, there's more information around the stepchild issue, but basically the stepchild is going to always be considered a child if the relationship, the husband and wife, get together and get married while the child is still under 18. And that is a very generous provision there. Now also notice whether or not born out of wedlock. So a stepchild can be a child from a previous marriage, a child from a previous non-marriage. So that child, the documentation proving the status of that child may not have like a father's name on it, may not have a mother's name on the birth certificate for that child. That's still going to be okay in terms of creating the valid child relationship. In the old days, it had to be born in wedlock, and so this is a big change that was really helpful to that. Now, there's another issue with the stepchild here, and that is what happens if the parent, the natural parent, dies before the adjustment of status. The Immigration Service is going to look to the relationship between the step-parent and the stepchild, and will make a decision based on the facts, so that if they have a bona fide parent-child relationship, then they will allow that green card to be approved, even though the natural parent of the child is deceased. I also think that's a very generous interpretation. So how about when a divorce happens? The step-parent and the natural parent divorce, and that stepchild hasn't gotten the green card yet. Then what? Well, they're saying that it's the same thing. If the relationship remains solid and you can prove that the relationship is still viable, then they will allow that stepchild to go forward and get his or her green card, even though the relationship, the marriage that created that stepchild relationship, has failed. So those are, I think those are very, important aspects of this law and understanding who a child actually can be. Here's another definition here. A child legitimated under the law of the child's residence or domicile, or under the law of the father's residence or domicile, whether in or outside the United States, if such legitimation takes place before the child reaches the age of 18 years and the child is in the legal custody of the legitimating parent or parents at the time of such legitimation. So a legitimated child is a child who, through a process, it can be a legal process in court, or it can be maybe the signing of an affidavit. There's different types of processes around legitimating a child, but there's always has to be some sort of process, some sort of action taken by a parent who is not on the birth certificate. So that, let's say I had a child out of wedlock and I was not on the birth certificate, and then I was from Ireland and I got married to a U.S. citizen, and I wanted to bring that child in as an immediate relative because it was my child. Well, the law allows for that as long as I have legitimated the relationship between me and the child. And so the legitimation of the child has to happen again before, what, 18 years old. and the child is in the legal custody of the legitimating parent or parents at the time of such legitimation. So legal custody then does not necessarily mean physical custody. That's why they use legal in there. So that when I go to legitimate the child, then the Immigration Service wants there to be a court holding legal custody. So the child has to be my biological child as well. So that's important. And the laws of foreign countries that create a parent-child relationship where none existed before are all over the map, literally. And you know, it's beyond the scope of this video tutorial to go into all the nuances, but there's a couple of examples here I do want to give you. And some jurisdictions consider a child legitimated if the biological father acknowledges or formally recognizes the child as his own. A father's acknowledgement is valid under the law of his residence or domicile, even if the acknowledgement occurred outside of that country. So, even though I might be from Ireland, if I legitimated the child in Yugoslavia, then, or the former Yugoslavia, Serbia, then it's going to be the law of where I'm living at that time. So it's going to be Serbia or China or Japan. So that's the important thing around the law, which law to use. And then the Immigration Service has a tendency to recognize the family laws of foreign countries, so that some countries might allow for just conduct, interaction with the child, to show that there's a legitimate relationship there. Others might require an absolute court process to show that there's a legitimation there. So when you're talking about defining a child relationship in the context of getting a green card through marriage, and there's no proof that the child is actually the biological child of the immigrant parent, then and if the child is over 18 years of age, it could be very, very difficult to qualify that child to get the green card along with the parent. So that's the bottom line on this. So if you're in the situation and you might have to work really fast to create a legitimation document or to do what's necessary to prove that the child is actually your child if your name's not on the birth certificate. D. A child born out of wedlock by, through whom, or on whose behalf a status, privilege, or benefit is sought by virtue of the relationship of the child to its natural mother or to its natural father, if the father has or had a bona fide child relationship with the person. So this one then is an out of wedlock child. In the old days, they would call this child an illegitimate child, and it was very offensive, because legitimate and illegitimate are just really harsh terms. So using a child born out of wedlock then was a way to acknowledge the fact that even though the parents weren't married, if both names are on that birth certificate, then that's going to be considered a child for immigration purposes. But let's look at this, because it talks about some of the requirements to show that the child is actually qualifies. There's a little extra thing here. Child born out of wedlock by, through whom, or on whose behalf a status, privilege, or benefit is sought by virtue of the relationship of the child to its natural mother. Okay, so if I marry a woman and the woman has a child and that child is born out of wedlock, my wife had the child with another father, no marriage there, but they're both on the birth certificate, okay, that's fine. It's going to be considered my child. But check this out. Or to its natural father if the father has or had a bona fide parent-child relationship with the person. Okay, the flip side then is that if I am from another country and I'm marrying a U.S. citizen woman, and I have a child through another woman with another woman, and we never got married, okay, then I'm going to have to prove that I actually had a relationship with that child to qualify that child as an immediate relative. And I'm going to have to prove that there's a bona fide child-parent relationship there. So different standards for women bringing in child born out of wedlock from a man. Then we get into E, the adopted children. A child adopted while under the age of 16 years. Okay, that's big right there. If the child has been in the legal custody of and has resided with the adopting parent or parents for at least 2 years. Okay, so it's not enough just to adopt before the age of 16. There also needs to be 2 years of residence, residing with. And legal custody. So the two issues then. Now, according to the source information that I have with the adopted child, it says, we're here, that the adopted child, the 2-year period of legal custody may occur before or after the adoption. Physical custody is not required to meet the legal custody requirement. The child need be in the legal custody and residence of only one of the adopting parents. Okay, so that's the part where it says at least 2 years, or if the child has been battered or subject to extreme cruelty by the adopting parent or by a family member of the adopting parent residing in the same household. So they give you, they also allow this part here for the battered child to to gain child status, provided that no natural parent of any such adopted child shall thereafter, by virtue of such parentage, be accorded any right, privilege, or status under this act. They're also saying then that once you adopt a child, and that child turns 21, normally children who turn 21 can file petitions for green cards for their parents. But once the child has been given up for adoption, that link is broken and they're not able to file for their parent. Or, for subsection 2, subject to the same proviso as in clause 1, a child who, 1, is a natural sibling of a child described in Clause I or subparagraph F, which is the orphan subparagraph below, was adopted by the adoptive parent or parents of the sibling described in such clause or subparagraph, and 3 is otherwise described in Clause I, except that the child was adopted while under the age of 18 years. Okay, so what does all that mean? If an adopted child, I adopt a child, and okay, it's supposed to adopt under 16 years. If they have a child, a brother or sister, I can go ahead and adopt that child, and it can the child can be under 18. So they give some flexibility for aging out for siblings, brothers and sisters then, of an adoptive child. That's also generous. Now here's the provision on the orphans, and this provision here gives all the information about what you have to do to get to apply for an orphan. A child under the age of 16, okay, got that, at the time a petition is filed in his behalf to accord a classification as the immediate relative under section 201B, who is an orphan because of the death or disappearance of, abandonment or desertion by, or separation or loss from both parents, or for whom the sole or surviving parent is incapable of providing the proper care and has in writing irrevocably released the child for immigration and adoption. So proving disappearance, abandonment, desertion, separation, there's a lot of stuff there on how to actually prove that. And it's beyond the scope of this video to go into that, but there are a lot of materials out there. Even on the website, the USCIS website has a very detailed treatment on adoption of orphans and the adoption of an orphan who has been adopted abroad by a United States citizen and spouse jointly, or by an unmarried United States citizen at least 25 years of age, who personally saw and observed the child prior to or during the adoption proceedings, or who is coming to the United States. Okay, so you're going to have personally saw and observed the child prior to. There's a personal contact requirement in this then. Or who is coming to the United States for adoption by a U.S. citizen and spouse jointly, or by an unmarried citizen at least 25 years of age, who have or has complied with the pre-adoption requirements, if any, of the child's proposed residence. So if there are pre-adoption requirements, then you have to comply, because we have treaties with countries, and you have to go in there and make sure that you complied with all of those important laws, provided that the Attorney General is satisfied that proper care will be furnished the child if admitted to the United States. So that is a home study requirement there that's in this statute, and part of that is required to actually get the visa, qualify him as a child, and get the permanent residency. Provided further that no natural parent or prior adoptive parent of any such child shall thereafter, by virtue of such parentage, be accorded any right, privilege, or status under this act. Okay, same thing. It's going to cut those cords between the child and their parent, so that those parents are not going to be able to be petitioned for by the child when the child turns 21. Then we have here the sibling provision, which talks about the 18-year-old. Subject to the same provisos as in Clause 1, a child who is a natural sibling of a child described in the above clause or subparagraph E has been adopted abroad or is coming to the United States for adoption by the adoptive parent or prospective adoptive parent or parents of the sibling described in such clause or subparagraph, and 3 is otherwise described in Clause I, except that the child is under the age of 18 at the time a petition is filed in his or her behalf to accord a classification as an immediate relative. So again, we allow a sibling, natural sibling, a little extra time to come in. They can be aged out over 16, but they still need to be under 18 years old. And then the final one here is a child under the age of 16 at the time a petition is filed on the child's behalf to accord a classification as immediate relative under Section 201B. So that's 16 as of the date I-130 petition is filed. Who has been adopted in a foreign state that is party to the Convention on the Protection of Children and Cooperation in respect of inter-country adoption done at The Hague. So this is what they call the Hague adoption category, and you know, it just basically sets out, as you can see in the statute, it incorporates an international treaty into the statute so that all these countries then can cooperate in the adoption of these children. And Canada and Mexico are both signatories to this treaty. And that is all of the Hague stuff. So there's the law with regard to who is a child. And so as we go back into the other areas of the website, then you're going to see this information is reflected in the other parts of the applications and petitions for children. So then let's go back to, I've got my back arrow here. I'm going to hit my back arrow once, twice, 3 times, and this one should be hit 4 times, 5 times. There we go. And remember, I did the search on child petition to get this informational fact sheet at the USCIS up. So now that we understand who a child is, what we're going to find out now are the requirements, the documentary requirements, and what applications and forms you actually file. Petitioning procedures. We love our procedures. Bringing a child, son or daughter, to live in the United States. This information is for U.S. citizens and lawful permanent residents who wish to petition for or sponsor their child to live permanently in the U.S. We are focusing on U.S. citizens because the scope of this tutorial is green cards based on marriage, and we know that if you're married to a permanent resident, then that immigrant is going to have a long wait. So we're not working on that one. We're working on someone who's here legally or maybe overstayed and is married to a U.S. citizen. Please note that, quote, child has a specific definition when used in immigration. Now we know that because we just went through the definition. You can review this definition by going to the USCIS webpage. How do I bring my child, son or daughter to live in the United States? Right. Well, we went to the law instead, and that's why we're doing the law. Okay. U.S. citizens. If you are a U.S. citizen applying to bring a child or son or daughter to the United States to live, and you are the mother of the child, you must file the following with the U.S. Citizenship and Immigration Services. Form I-130. Okay. Copy of your birth certificate or U.S. passport. If you were not born in the United States, a copy of either your certificate of naturalization or citizenship or your U.S. passport. A copy of the child's birth certificate showing your name and the child's name. If anyone's name has been legally changed, if it differs from the name on his or her birth certificate, evidence of the name change must be submitted. So that is the I-130 information that you need right there. Now, Remember, when we're going for a green card, though, we're going to want to file an I-485, get a green card for the child, right? We're going to want to file a work authorization card to get a work authorization card for the child, a travel document for the child. We're going to want to get G325A applications for the parents and the child, or the petitioning parent, the one who's actually signing the I-130. So, you know, that's, and those documents, those forms, then you can use our other tutorials to fill out and put the information for the children in those applications. And remember, there's also special filing fees for children. So you're going to want to check the filing fees on the adjustment of status, the I-485, and for this I-130. Now let's look at the next one. If you are a U.S. citizen and the father or step-parent of the child, or son or daughter, you must file the following with the U.S. Citizenship and Immigration Services. Form I-130, petition for alien relative. Copy of your birth certificate or U.S. passport. Okay, I'm proving I'm a citizen. If you were not born in the U.S., either naturalization certificate or your U.S. passport. Okay. But now it goes into more information. A copy of the child's birth certificate showing the child's name and the names of both parents. Because this way we're talking about a child that is born in wedlock. Remember, a child born in wedlock is, you know, obviously going to be able to get a green card here. A copy of civil marriage certificate showing the names of both parents, or proof that a parent-child relationship exists or existed. If you are petitioning for a stepchild, your marriage to the child's parent must take place before the stepchild's 18th birthday. Well, there it is right there. So the marriage certificate with the date and both names of each spouse, right, showing that it was entered into before the stepchild's 18th birthday. A copy of any divorce decrees, death certificates, or annulment decrees that establish the termination of any previous marriages entered into by you or your spouse. Okay, we have another video tutorial on those types of the death decrees and the issues around marriage. Fathers petitioning for a child born out of wedlock. Okay, we talked about that definition. Must provide evidence that a parent-child relationship exists or existed. For example, the child's birth certificate displaying the father's name, evidence showing that the father and child at some point lived together, or that the father held out the child as his own, or that he has made financial contributions in support of the child, or that in general his behavior evidenced a general concern for and interest in the child. A blood test proving paternity may also be necessary. So that's why we're talking about, these are, you know, legitimating. How do we legitimate? Well, they're saying that there's a leeway on proving a legitimate parent-child relationship for a child that's born out of wedlock. If anyone's name has been legally changed, it differs from the name on his or her birth certificates, evidence of the name change must be submitted. And that is a very good point, because when the name cannot be traced or cannot be authenticated, then it really drives the Immigration Service crazy. So make sure that you have name changes with regard to parents. If there's a divorce and a marriage certificate, then that's going to show the pathway of the name and how it evolved. If you are a U.S. citizen and the adoptive parent of a child or son or daughter who lived with you in your legal custody for 2 years while a child, you must file the following with U.S. Citizenship and Immigration Services. Okay, the I-130, copy of your birth certificate or U.S. passport, same things there. Copy of the child's birth certificate showing the child's name. Now, a certified copy of the adoption decree. The adoption must have taken place before the child reached the age of 16, with only one exception. If you adopted the child's sibling who had not yet reached age 16, the older sibling must have been adopted before reaching the age of 18. Okay, remember that? The legal custody decree if you obtained custody of the child before adoption. Okay. A statement showing the dates and places your child has lived with you, and proof that your child has lived with you and has been in your legal custody for at least 2 years. So a statement then means a sworn statement under penalty of perjury, notarized, and it is a letter, it is a written statement by you. And then again, the name change. So what's the common denominator in all of these? Well, it is the Form I-130, the birth certificate showing that the parent is a citizen, and the child's birth certificate. Because remember, children of U.S. citizens are immediate relatives, and they can adjust status here in the United States, or they can obtain immigrant visas immediately. And under the Child Status Protection Act, as long as the adjustment of status or the immigrant visa application, the I-130, is filed before the child ages out, then at 21 years of age, then you're going to be okay to get that immigrant visa or adjustment of status. But it's more than just 21, because as we're learning, there's different ages where things have to happen. So it's important then to dig into this stuff and understand what are the requirements. Then we go to orphans. In each case, if the child is in the U.S. and unmarried and under 21 years of age, he or she may file a Form I-485 application to register permanent residence or adjust status concurrently with your petition. Right. For information on how to file this application, please refer to How Do I Become a Lawful Permanent Resident While in the United States. So this orphan, I think, needs to be down here. This is all relating up here to what we just talked about, the classification of these children as immediate relatives, and they're just saying you can file the I-485. But then the orphans, for more information, you also may refer to How Do I Apply to Bring a Foreign-Born Orphan into the U.S. Well, here it is right up here to the top right. See it? How do I apply to bring a foreign-born orphan into the United States? Let's click on that. I want to show you this. There is a ton of information on this one. And it's done, I like the way they do this in a question and answer format. Who is considered an orphan? Right? Who is eligible to file an orphan petition? Where can I find the law? We've looked at that. How do I apply? Check this out. The fastest way is to file USCIS Form I-600A, Application for Advanced Processing of Orphan Petition, before you identify a foreign-born child to adopt. This allows the USCIS to first process the application that relates to your ability to provide a proper home environment and your suitability as a parent. Then, once a child who meets the INA's definition of orphan is identified, you must file USCIS Form I-600, Petition to Classify Orphan as an Immediate Relative, on behalf of the child. And what is the quickest way to bring a foreign-born orphan that I adopt to the U.S.? That's a question everyone always asks. I want to get the child here quickly. Because a lot of times orphans are abandoned by definition, so they're at risk. So if you know then that there's something going on in a foreign country where there's civil unrest or there's a family situation, you can file the I-600A up here for advanced processing, and then the I-600. What kind of information about myself and my spouse will I as a petitioner need to provide to the USCIS? Okay. Fingerprinting and procedures and the adoption application process. See, there is an adoption overlay to bringing in an orphan. And then here's what kind of information about the child will I need to provide to the USCIS. Child's birth certificate, or if the certificate is unavailable, evidence of the child's age and identity. Yeah, a lot of times those birth certificates are not available. A proof that the child is an orphan as defined by the INA. So, you know, those proofs, you know, I think they covered here, and it's, you know, it can be difficult because of, especially in situations where there's a war going on. A lot of the documents are not available. However, you can take a step back and show that the whole society is broken, and that there's a breakdown in the social structure, or there's a famine or some natural disaster going on. Then that will also help with determining that the child is neglected or abandoned, or, you know, that the parents are deceased. And then where can I file my application? And then also, you know, there is the application, the I-600, and there's an instruction sheet on that. So that's another way to get good information on the foreign-born orphan application. And here's that application right here. So those are the classifications of the children then. And there are, when you're filing for a child that's born out of the country, it's, you know, it's not that much more complicated than filing for an adjustment of status. And, you know, this video tutorial links up with our adjustment of status video tutorial. So the understanding is that the immigrant spouse has brought the immigrant child, and the immigrant child is here, so that way you can file the I-130 and all the other documents on behalf of the immigrant child and do that adjustment of status here. But there are other video tutorials that talk about the consular process, the process by which immigrant visas are obtained at the consulate, and so the child would go with those procedures in that type of a situation. So there you have it. That is a rundown of the rules with regard to applying for children when it's based on marriage to a U.S. citizen here in the United States. And you can see we went right through the law and through the procedures. And with that being said, we wish you all the ease and success in getting the green card that you and your family so richly deserve.